So goals of today's presentation. So I want to provide an overview of the draft regs and guidelines. And really, I think there is um, a lot we could talk about and not enough time, I think, to really go through all of the minutiae of the regulations. So I really wanted to focus on what are the potential impacts to municipalities in our region and across the state. I think some of those changes are more clearly defined than others, and others are um, frankly going to be our interpretation of what's in the draft regulations and guidelines. I think you'll see a little, further down, in this presentation that it is a number of different regs and guidelines that are all kind of interlinked, and it's not, there may be some places where things aren't entirely clear, and we're sort of giving our best interpretation of what we think those are. Um, we were not involved in developing these draft regulations, so any of those interpretations are our own, may not align with the intent of DOER, EFSB, EEA, or other state agencies, or the legislators who passed the laws in the first place. Um, Lastly, I want to highlight some opportunities to learn more directly from state agencies and weigh in with comments within the public process. Uh, it's been a lengthy timeline to get here. Little over 2 years ago, Governor Healy established the Commission on Energy Infrastructure Siting and Permitting. That commission was tasked with developing recommendations to streamline the siting and permitting of clean energy infrastructure with the goal of ensuring the state can meet its long-term clean energy goals. MAPC participated in that through our executive director, Lizzie Wyant, representing municipal voices. After a 6-month period, the commission submitted recommendations to the governor, and then the state then filed legislation with the legislature later that spring. The legislature ultimately took that up and incorporated largely the recommendations and proposed legislation as proposed in the 2024 climate law at the end of November. Um, Over the course of this year, kind of starting in Q1, Q2 of this year, the state agencies tasked with developing the regulations and guidelines began getting to work. For some of these agencies, it was quite a lift to get started. The Department of Energy Resources, for example, had to establish an entirely new division of siting and permitting to then be able to develop these guidelines and regulations. And so it's been a road to get here, and also fairly rapid. Right now, we are in the middle of the public comment period for the draft regulations and guidelines, most of which were released about 3 weeks ago. Um, what's driving this really quick turnaround is the legislation very clearly states the deadline to publish final regulations is March 1st. That deadline was, as written, back in April or May when the proposed legislation was submitted. Even though the law didn't pass till several months later, this deadline wasn't adjusted. So we have the deepest respect for folks at the state who have been really sprinting to get this done, and also the acknowledgement that in that timeline there are definitely things that they are seeking a lot of input on to improve. Um, how this will then translate on the ground is that the statute does require for the Energy Facility Siting Board, or EFSB, to put their regulations and new processes into effect by July 1st of next year. The law does not specify when municipalities need to incorporate the DOER regulations into their local processes, but as you'll see, the proposed date for doing so in the regulations is December 1st. And again, the goal of these reforms is to balance both, I think, the goal of creating an efficient and consistent permitting pathway that can enable the clean energy scale up that's needed to meet the state's long-term climate and energy goals, and balance that against the municipal needs, the autonomy of municipalities, and to enable municipalities to protect against and mitigate environmental and health and safety impacts. This is a graphic the state has used pretty regularly to kind of illustrate the differences between the previous or current process and what is proposed under the regulations and under the new law. Right now, each project must apply for each permit individually from each authority holding jurisdiction at the state or local level. This leads to a real patchwork with no clear timeline on making decisions. Each individual permit gets appealed directly to another entity, and so in some cases projects can take 5 or 10 years to complete before they can begin construction. The new process aims to streamline this by separating projects into two primary pathways, one for smaller projects and one for large projects, uh, with the goal of having a consolidated application for in either pathway, and a duration that is fixed for when the decision needs to be rendered, as well as a clear appeal pathway. To clarify what is meant by smaller and larger and what is actually encompassed in this legislation, small clean energy infrastructure facilities are defined as generation projects that are under 25 megawatts in capacity. That is inclusive only of solar photovoltaics or PV, onshore wind, and anaerobic digestion. This pathway does not exist for fossil fuel generation or other forms like hydrogen. Small also includes storage under 100 megawatt hours, shorter transmission projects within existing corridors or even shorter ones in new corridors, and then distribution projects like substations that are aiming to help support grid reliability, stability, and facilitate decarbonization, through interconnecting other clean energy infrastructure or encouraging electrification. Large facilities are going to be the ones all above that. Um, and the main distinction here is that the smaller facilities will go to municipalities for review. The larger facilities will go directly to the Energy Facility Siting Board to do so. There are a lot of regs and guidelines, for this process. The smaller projects the regulations are developed by the Department of Energy Resources. Those regulations make reference to numerous sets of guidelines that are also available for review. Related to, but not directly part of the same process, but sort of inexorably tied to the process are a set of draft model zoning bylaws that the Department of Energy Resources also has put up for review. That includes an updated draft model zoning bylaw for solar. That's an update from the 2014 version, as well as a new draft model bylaw for energy storage. The EFSB also has its own set of regulations and guidelines. And then the Executive Office of Energy and Environmental Affairs has a set of common guidance and guidelines and standards that are referenced by both sets of regulations from DOER and from the EFSB. Lastly, there's also further separate docket from the Department of Public Utilities for draft regulations on an intervener support fund, which would enable grants to support folks in intervening in cases before the EFSB. Everything about this process and these guidelines and regulations can be found at mass.gov/energy permitting. So I know this slide is a lot, but this is our attempt at trying to find the key points that are really new or substantially changed in the process, and highlighting how those have been incorporated into the DOER small infrastructure and the EFSB large clean energy infrastructure pathways. The first is the consolidated permitting approach. The application submitted to municipalities or the EFSB will be a consolidated application that includes an application for all of the permits, approvals, and authorizations that would otherwise be issued by the municipality or by the EFSB. That does not change that the individual boards, departments, offices, authorities, etc., that would be otherwise issuing permits or approvals. They will still be doing their review, but the process of application is consolidated through a single point, and the decision is on all permits consolidated. This is the same at the state level, and include for the state at the FSB level can contain local, regional, and state permits. As for timelines, municipalities, upon making a determination of completeness of the application received, have to render their final decision in 12 months. The EFSB has 15 months to make their decision. In both cases, if the project is not, a final decision is not rendered in that time, the project receives constructive approval to proceed, subject to a set of common conditions that are articulated in guidelines and regulations. The regulations and law establish new pre-filing requirements that must occur in advance of when a permit application is filed. That includes pre-filing stakeholder engagement activities that have to occur at least 60 days before the application is filed, that are kicked off by a notice of intent at the local level. Within those requirements are things like public meeting requirements, clear requirements on what information needs to be available about the proposed project at that time, and a number of other requirements. At the EFSB level, there are even more requirements for engagement and consultations before the application is submitted, including the applicant being required to consult with all of the municipal authorities that would otherwise have been required to issue a permit themselves, have the project come before them. One of the things that the law requires is establishing a common set of health, safety, and environmental standards. I think it's, the way I think this has been framed, which I think is a fair way to think about it, is that these are sort of our baseline public health and safety standards and environmental standards. So DOER has issued guidelines for these baseline standards. There is an avenue for municipalities to potentially adopt additional reasonable standards for purposes of public health, safety, or welfare on top of those guidelines. EFSB following a similar route, though one of the changes to the process is that projects that go through the EFSB are exempted from going through the Mass Energy Environmental Policy Act requirements. The appeals process has been clarified. Instead of appealing each individual permit, the entire consolidated final decision at the local level is appealed for de novo review by the EFSB, who has to render a decision within 6 months. Either the applicant or any individual or entity significantly or substantially affected by the final decision by the project can file that appeal. Any appeals of the EFSB decisions, whether it's for a large project or for de novo review of a smaller local project, is appealed directly to the Supreme Judicial Court. Another thing that was required by the law was for the siting process to take into account the suitability of the site for hosting infrastructure, as well as potentially an analysis of what are some of the prior public health and environmental burdens that have been experienced in the community the site is located in. At the local level, through the small clean energy infrastructure facility pathway, that is a site suitability assessment that needs to be conducted by the applicant in accordance with the methodology that's been defined by guidance issued by EEA. That site suitability assessment takes into account a variety of factors, ranging from the potential for climate impacts to that site, and then other impacts of that infrastructure related to things like forest carbon, biodiversity, farmland, and existing environmental and public health burdens. Through EFSB, if the project is determined to be in what's called a burdened area, a further analysis has to be done, or rather in place of a site suitability assessment, to complete what's called a cumulative impacts assessment, where the applicant will then also need to look at all of the prior environmental and public health burdens that are associated with the site that they are proposing. The intent of these assessments are in part to be tied to minimization and mitigation activities that can be required as a condition of proceeding with the project. Lastly, this is something that MAPC's perspective since the commission has been that we generally support the overall goals of streamlining and adding standards and common standards and consistency to the clean energy infrastructure siting and permitting processes. But we recognize that we'll need significant technical assistance and support for municipalities in order to implement. Some of those have been incorporated into the regulations for DOER. DOER's regulations identify a regulatory circuit rider program to provide guidance to municipalities on locations, the review process, site suitability analyses, and developing mitigation recommendations. That's intended to be similar to what the Department of Environmental Protection currently uses. The new Division of Siting and Permitting has a suite of regional coordinators that are available to support municipalities. And the regulations also clarify that permit fees that can be set for clean energy infrastructure can be used to set in a way to hire external technical expertise to support the municipality with its review. At the EFSB level, there is, as I mentioned, there is an intervener support grant fund that is created by the law that funds that can fund the intervention in EFSB cases. Typically, that's a fairly involved legal process, adjudicatory process that involves hiring outside counsel to be able to fully intervene. And so that is what the intent of the grant program is to support. There's also a new DPU division of public participation that has been established to assist local governments before the EFSB or DPU. I'm not going to spend too much time on the large CEIF pathway through EFSB. I just wanted to highlight, I think, some of the larger changes here. The first in issuance of the consolidated permit, it I think doesn't really change a lot of what's already under EFSB's purview, except that it clarifies and centralizes this for the clean energy infrastructure in particular. The EFSB already can currently grant comprehensive local zoning exemptions and issue certificates that grant state and local permits. And so it can continue to do so and has been expanded to incorporate all of the clean energy infrastructure facilities that are noted here. For intervention purposes, currently municipalities can file requests to intervene in cases as an intervener or a limited participant. Under the law, all municipal entities that would otherwise be issuing a permit are automatically granted intervener status if they request it, and then can apply for grants from the Intervener Support Fund. The law and the proposed regs identify a number of places in which municipalities directly need to be consulted or are invited to participate in the process. During the pre-filing engagement process, the applicant has to consult with all of the municipal entities that would otherwise be issuing permits to receive feedback on their application. Municipality can propose changes to the project and mitigation activities, and can also provide feedback on whether the pre-filing consultation was adequate or effective, since the Division of Public Participation makes a determination of whether those pre-filing requirements were completed satisfactorily. The application, municipality can weigh in on whether they feel the application is complete. From a procedural perspective, at least 3 weeks before the initial evidentiary hearing EFSB holds, the municipal permitting authorities are invited to submit statements of recommended permit conditions, had they been the ones issuing the permit. And EFSB has to provide due consideration to those findings and recommendations of local governments. What I want to spend a little bit more time on is the process for that will happen at the municipal level, since we are really focused today on the impacts to municipalities. As mentioned, there's at least 60 days of pre-filing requirements from the notice of intent prior to the submission of a consolidated application. Once that application is submitted, the municipality has 30 days to determine whether it is complete. The municipality, at any point within 60 days of receiving the application, can decide that they lack the capacity to review the project and can request that the EFSB adjudicate the project instead. If the municipality decides to review it themselves, they have up to 12 months to do so and issue a final decision. The 12-month timeline isn't met, the project receives constructive approval. And again, the applicant or anyone significantly or substantially affected by the project can file an appeal to EFSB for de novo adjudication. Some of those pre-filing requirements include the notice of intent with basic project features and a pre-filing stakeholder engagement plan. There are guidelines that recommend a number of best practices for pre-filing engagement. One of those is an alignment meeting with municipal officials to discuss the project and confirm requirements. It's not required under the regs, but it is recommended under the guidelines. The applicant's required to have a public meeting with open to key stakeholders, and provide notice at least 14 days before. They have to, provide a notice to abutters, ads in local media, information for the municipal website, and post things on at least 3 public buildings. They also need to have completed a preliminary site suitability assessment, and also submit a pre-filing engagement completion checklist to the municipality that attests that they've completed all of these requirements. The site suitability score, which we'll talk a little bit more about, is submitted to a reviewer determined by the state at least 45 days before the application can be submitted. That reviewer has 30 days to issue a final decision on what the site suitability score of the application is. Key stakeholders can request review of the score by DOER. It seems like this could include things like, if the maps are inaccurate that are being used and such, and the final score ends up being what is used in the application. The municipality is also asked to make the determination about whether the applicant has completed all of these pre-filing requirements, and the applicant has 30 days to cure any deficiencies before they submit an application. Once they do submit the application, the regs provide for a whole list of information that has to be included in a consolidated application. Currently, the plan seems to be, that DOER will provide like a PDF version of the consolidated permit. But eventually, I think their aspiration is to have an online portal like DEP uses right now. Again, municipality has 30 days to determine whether the application is complete, and notifies the applicant of what their determination is. Municipality, the applicant gets 30 days to cure any deficiencies, and the muni can provide an extension after the initial 30 days or deny without prejudice, I should say with. So during that review, again, one of the key part to note is that the application itself and the final decision is consolidated, but the individual permitting reviews that would otherwise have occurred in the absence of this pathway still occurs with the individual boards and departments. The individual reviews of each permitting authority can occur concurrently or consecutively at the discretion of the municipality. And each of those permitting authorities, can issue decisions on the individual application components. They can choose the grant with conditions, or deny. Because we're working under an accelerated time frame here, there is an assumption of good faith and prompt communications. The regs note that applicants must respond to communications from the municipality within 3 business days and submit revisions within 7 business days. No, getting back to the board in 2 months and running out the clock, unless the municipality grants them additional time. Similarly, no making superfluous requests for information to try to test the responsiveness. Again, because the application is consolidated, it is denied in full if any one of those permits is denied. Regardless of what pathway the municipality is choosing for how and when their respective agencies or boards or departments are sequencing their reviews, all of those entities must complete the review, regardless of whether any individual authorities have decided to deny the application for, because this all needs to be built, put into the record for purposes of the EFSB appeal. And the appeal to the EFSB is for de novo review of the full application and not just the individual permit component that may have been denied. Again, we still have more to learn about what the circuit rider program will look like in practice, but it is identified as an avenue for providing technical assistance to both applicants and municipalities. I think just, again, the de novo adjudication of municipality's decision occurs with the EFSB within 6 months. This aspect in the appeals process is described in the EFSB regs, not in the DOER regs. And municipality, again, has to file all documents produced during that consolidated permit process. And at the EFSB's discretion, it could include evidentiary hearings, oral arguments, or filing of written briefs in which the municipality would probably be likely to participate in. And appeals to the Supreme Judicial Court have to occur within 20 days of that the EFSB's decision. So talking about site suitability assessments, this is the assessment of the suitability of the site selected for the project based on a variety of risks and impacts. This methodology has been articulated, it has been established by EEA's guidance and relies on a variety of publicly available state and national mapping tools. It's actually pretty methodical to the extent that I've heard state staff say, it could be possible to automate this in the future. Excluded from needing to conduct site suitability assessments are projects with a site footprint of 1 acre or less, transmission or distribution infrastructure sited in the existing right-of-way, solar PV under 25 kilowatts in capacity, and other behind-the-meter small clean energy infrastructure facilities under 250 kilowatts. Also, larger projects that are located in burden areas will complete cumulative impact assessments instead of site suitability assessments. The way this scoring works is basically from a low score, which is higher suitability and lower impact, up to a higher score, which indicates lower suitability for the infrastructure and higher environmental impacts. Those criteria include what is the exposure of the site to flood risks, carbon storage and sequestration from what's being potentially displaced, as well as biodiversity, farmland and agricultural resources, and then looking at social and environmental burdens with the forthcoming Mass EnviroScreen score. This is on each criteria is on a scale of 0 to 5. The individual criteria scores do matter, and then there's a total score up from 0 to 25. There are some other things that sort of affect how the suitability scores work. For example, if the project is proposed in protected open space, it automatically receives the highest maximum score of 25. If it is proposed in a brownfield, eligible landfill, or previously developed lands, with the exception of the climate resilience option, they immediately get a score of 0 for all of those. It's then other things like if it's located in a capital investment project area, which are areas that have been under a group study for build out of grid infrastructure to facilitate the distributed energy resource build out, then a point is removed from it. And then certain social and environmental benefits that can be provided through signed community benefit agreements with the host community can reduce scores by up to 5 points. The importance of these scores is that they inform the development of minimization and mitigation measures. There's a guidance from DOER on what those minimization and mitigation measures could include. They have sort of like a menu of example options. The idea is that municipalities can require these activities to occur as a condition of permitting commensurate with the level of impact in the criteria scores, and ensuring that those minimization or mitigation activities have a rational nexus to the criteria score. Making sidewalk improvements on a different street is not a rational nexus to removing mature forests. There's a no net loss goal that is articulated for replacing impacted environmental resources. If the project has a sufficiently high score, the municipality can require a compensatory environmental mitigation fee, which can fund other local or regional environmental mitigation activities. This is tied to the Smart 3.0 mitigation approach. If you're familiar with those, it makes direct cross-reference to the SMART regs and the land use guidelines there. But it's basically the maximum fee is currently set by those guidelines is $50,000 per acre, and that's scaled to the site suitability score. So this is the point where I think we're definitely looking at a little bit more interpretation, because some of these things we're not 100% sure about. The thing that is clear is clearly spelled out is that municipalities will have to comply with the new regulations and guidelines by December 1st of next year as proposed. That includes includes adopting the consolidated local permit application process being defined by the state. Each municipality will have to establish some sort of process for reviewing applications. That includes identifying points of contact for coordinating a lot of these, the application review, the pre-filing requirements, the ultimate permits and decisions, and enforcing permit conditions. Have to develop some sort of consolidated local permit application review process, figure out whether they're reviewing concurrently or consecutively, establish what the application and permit fees are. As needed, this could include adopting a permitting bylaw or ordinance, and DOER is developing a forthcoming model permitting bylaw that municipalities can adapt. Municipalities may need to review zoning bylaws for compliance with the regulations and guidelines. It's not 100% clear to me what because there are definitely some very robust zoning bylaws for solar storage and other infrastructure on the books in a lot of communities. It's unclear whether the guidance that's been issued here will require amendments to those bylaws to incorporate other sort of additional standards that might go beyond what's already in place in communities. Something I think that to speak more with DOER about. This is a big question we get a lot. What protections are in place for public health, safety, and environment? There is, again, that guideline on baseline public health, safety, and environmental standards. If you're concerned about this, highly recommend looking at it. It's a fairly extensive list in table form of a whole range of general standards for all projects, and then specific requirements for each technology. So there's all kinds of things from these code and safety standards, monitoring, discharges, et cetera, things that are listed here, as well as for example, prohibition on projects on slopes of greater than 15 degrees, and then some technology specific criteria like glare related provisions for solar PV, and explicitly clarifying that municipalities can restrict battery energy storage in Zone 2 wellhead areas. The regulations note that municipalities may adopt additional standards provided such standards are reasonably necessary to protect the public health, safety, or welfare and do not conflict with the standards that are in the regs or guidelines. That language sounds somewhat familiar. It's because it does sort of align with some of the language in 40A Section 3. Under the law says that municipalities that are in compliance with DOER's regulations and guidelines will also be considered in compliance with 40A Section 3 for the solar and storage provisions. That's not to say, though, that the additional standards may be subject to review for compliance with 40A Section 3 if you go above and beyond those regulations. That's a little bit unclear and is a legal question that is beyond what I think what we can interpret here. And again, there are minimization mitigation requirements for that increase with higher suitability scores. What technical assistance and resources are available to support municipalities? Again, the regulatory circuit rider program as proposed. I'm sure we will be learning more about what that will look like in the coming months. Again, it clarifies that permitting fees can be set in a way to charge to hire external experts or consultants to support the municipality with reviewing applications. The regional siting and permitting coordinators will be a direct resource. They are very similar to the green community siting, green communities coordinators. And that there's potentially a role, we're exploring how best for RPAs to be able to provide more support to municipal staff with both the adoption of these regulations and guidelines and their ongoing implementation. There's the Intervenor Support Fund for things at the EFSB level, and then a whole set of model bylaws. There is a forthcoming model permitting bylaw. DOER hasn't released it yet, but that will be forthcoming, and I presume opportunity for comment on that as well. And then a set of updated and new zoning bylaws for solar PV and energy storage. They've articulated there will be more guidance coming, and definitely worth considering what would be most helpful here. And they're all ears on what things might be most helpful. I found them to be very responsive in all the I think 5 or 6 meetings I've been on with staff at DOER. These are just some off the cuff observations from our end. We think the timeline December 1st may be challenging, especially with town meeting schedules and how things line up with Attorney General's office review, municipal law unit review. There are touch points early on in the process for both the municipality reviewing both the pre-filing requirements and the completeness of the application in separate steps. That may be one more touch point than we need. Additional meetings with municipal staff before filing the application are recommended, but not required. Maybe they should be more clearly required. Key stakeholders are defined as residents within 1 mile of the project. That's maybe too much for communities like Boston and maybe too little for the most rural communities. There are no other exemptions besides site suitability that are currently built in for small residential and accessory use projects. DOER did note, I made this comment yesterday at their evening hearing, and they did note that they were looking into how best to do so to not overly burden things like residential rooftop solar. There's the quirks of how the site suitability scores line up is that it's probably unlikely outside of open space projects that you'll see site suitability scores add up to 25 because things can't be prime farmland and the densest forests and priority habitats kind of all at the same time. The regulations and guidelines, I think in general, because I think trying to avoid having blanket rules and where possible, are kind of hesitate to specify what aspects of a project, whether extremely high site suitability scores or other aspects might allow for a municipality to deny a project outright. I think this is an area that DOER is looking for more comment on. If you have questions about the DOER regs, I highly recommend reaching out to your regional coordinator. You may see if joining us today is Connor Rocket, who is the Southeast Regional Coordinator. We also, in MAPC's region, the other will be Marcela Castillo for the Northeast, and then I think Stephen Mino has a few of our communities on the western edge, and then Allison Gage in the West region. It's the same as your Green Communities region. There's one more evening info session tonight that you can sign up for. I found these to be very helpful as well. Great opportunity to ask questions. I've been to two of the 3 so far. And then public comments, because there's a lot of different sets of regs and guidelines. Verbal comments can be given on the regulations next Wednesday, the 15th at 7. Written comments are due by Friday at 5 o'clock. The guidelines themselves will have a different comment period, though you can still make comments. I'm told from DOER that you can still make comments on the guidelines as part of your comments on the regs. And then draft model bylaws were developed by Green Communities, and they have a separate, but again, since they're kind of inexorably linked to this, the draft model bylaws are due, comments are due next month on the 14th of November. EFSB has its own set of separate public comments hearings, and written comments there are due on November 7th. Here are some questions that are sort of consolidated from some of the questions that we have for you all, as well as some of the questions DOER has been posing. Is the timeline for implementing these regs realistic? And if not, what would be? Right now, it's proposed by December 1st. Um, one question is, should communities be able to just deny applications if the site suitability score is too high, regardless of the extent of minimization or mitigation measures? It's definitely, I think, intentionally not clear in the regulations, and this is a question that DOER has posed to stakeholders. Um, are the pre-filing stakeholder engagement requirements sufficient? And if not, what other methods of outreach would be beneficial to require, and how should it, uh, how should it change by um, how should it differ by the size of the project? Right now there's a whole set of proposed pieces, and then things like a municipal alignment meeting are recommended in the guidelines, but not necessarily required. More broadly, what tools or guidance do you feel you would need to calculate, to determine and mitigation that's necessary to offset higher site suitability scores? Um, Beyond what's proposed, what other health, safety, environmental standards should be important to include in the sort of like baseline floor of common standards across all projects? What other standards for projects should be included? Uh, More generally, where do you see the most need for tools, resources, or technical assistance to support your community with adopting the regulations and reviewing projects? And lastly, what else is missing from the regulations, and what are you most concerned about? We will circulate these slides as well as the recording afterwards. It would be great to, hear some initial questions now, and also if you have follow-on comments. Let's take a look at what's in the chat. Let's see. William Lake, will these regs apply to projects by a municipality itself, or only to projects proposed by someone in the municipality? Actually, a good question. I don't know, Connor, Connor, do you have yeah, I realize I haven't actually thought about that very much.
Sure. Thanks, Jeremy. So under the regulation, a applicant is entitled to this new consolidated permitting process and entitled to receive a decision that will allow them to either go forward with the project or whether it's a denial within that 12-month time period. So to the extent that a municipality is the one, you know, leading the project, you would not, and you feel that you do not need to, comply with that 12-month timeline against yourself. You don't want to enforce that 12-month timeline against yourself. That would, be an option. But for private developers that are proposing projects within the municipality, they have the option to go under this 12-month time period. And then I do see just one set of questions asking about exemptions for residential rooftop solar. That is correct. The regulations do not cover residential rooftop solar projects. Those projects are exempt from this process entirely. And a solar facility within the regulations is defined as a ground mounted solar system. So this process that has just been covered does not apply to residential rooftop systems, and those will continue to be permitted as they currently are.
Oh, that one's helpful, Connor. I forgot that that was in the definition of it because I wasn't sure because it was, there are a lot of places where it doesn't quite specify. I think maybe in West, probably in the central and western parts of the state, there may be, residential ground mounted systems that may need some sorts of exemptions within it. I think that but it does seem, Alicia, to your questions, the goal is that, to not necessarily add any new layers to, small residential or commercial projects beyond what's already in place. Priscilla, who gets to approve the site suitability assessment? That is a third party to be determined by the Department of Energy Resources. They will serve as the reviewer. If anybody has an issue with the approved score, there's also a pathway to request review by DOER of that, that reviewer's final score, and whatever DOER's decision is final. Let's see, Jeff Roberts. Lisa, questions. Um, I believe, Jeff, the answer to your question is thinking of what is meant by all permits. I think it means anything that the municipality would need to issue except for the final issuance to construct, I believe, is the only thing that is excluded here because because I think DOER contemplates it as a lot of work to prepare the final schematics and other materials to receive that that final issuance when there's still an appeal process ongoing. Um, and I think again, I think you also asked, how does the timeline of the regulation align with the statutory timeline for component permits? Special permits require a hearing within 65 days and decision with 90 days. Um, the individual boards, still retain their same timelines. It's just that the overall timeline for all of the permits together need to happen within 12 months. So there can be a patchwork, things that happen consecutively or concurrently during that process. William Lake, will DRR put out local bylaws? Yes, the zoning bylaws are available now, and the permitting bylaw is forthcoming. See, Alicia, I think we talked about about rooftop solar. Let's see, and it is December, sorry if I misspoke, it is December 1st, 2026. See, from Sean, is it intended that there will be a consolidated local permit application template model communities are recommended to follow or adopt? Are municipalities creating this application individually in compliance with regs or guidelines? DOER will be providing a template, is my understanding, and there's a set of guidelines specifically about the consolidated permit. Can the 12 months be extended if it is mutually agreed upon in writing by the municipality and the applicant? I don't think so. I think 12 months is written in by the statute, but I don't know, Connor, if you all have discussed that separately.
Yes, so that is something that we were looking into early on as we were crafting these regulations. And based on the assessment of our legal team, the statute does not provide for a opportunity to extend the 12-month timeline. So there is not actually an opportunity for an extension by mutual agreement.
Yeah, I put the definition of solar facility from the regs in the chat. It is very specific that it is a ground mounted facility that uses sunlight to generate capacity. Let's see. Why is this the selected pathway and what are the anticipated consequences of non-compliance? A good question. I mean, this was these pathways were developed through if you go back to beginning of this process, this came um, from a commission that was convened by the governor to identify recommendations. Those recommendations informed the development of legislation and were then passed by largely as is by the legislature last year. So I can't speak to the consequences of non-compliance. I think I think what's most likely is that if a municipality is not in compliance, um, then applicants would be able to just immediately appeal to the EFSB, and the EFSB would do its own review, assuming that municipality is not in compliance. But I'm not a lawyer. Would this cover new substations? Yes, substations are included in the definition of small infrastructure. I will note that there's some projects that are smaller might require state permits. Those state permits still have to be obtained separately, either through the state permitting authority or by filing a separate application to the EFSB just for those state permits, while the local permits are still handled by the municipality. If the municipality typically only sees small rooftop arrays, does that mean you still need to go through the process of establishing the consolidated local permit application process and modifying its bylaws in case a ground-mounted array is placed somewhere? That is a good question. I think, that this is one of the things that's been a little bit unclear to me and is frankly a concern because I know a lot of our communities have put a lot of time and resources into developing, what or bylaws that frankly were some of the basis for some of the models that were developed by DOER, and it would seem, it seemed like an additional burden to make some modifications to them if there are other standards that could still be enforced independently of the bylaws. But I don't know. What's your thought on that, Connor?
Yeah, I guess I would say that um, to the extent that that community may also be more like proactively permitting battery energy storage systems, you would also want to update the bylaws uh, for that reason. Um, but so, you may not be a community that has much available land for ground mounted solar arrays, but you may have more opportunities for battery systems that fall under the regulations. So I think that is probably how that process would come together. But to the extent that a community is in compliance with the regulations by December 1st, 2026. I think that is the standard uh, that the enforcing, powers, whether it's the AG's office, would be looking at.
Yeah, I think there's definitely, it seems like, for example, rooftop solar is exempted, but I think there's definitely, I think we heard in other, previous, public sessions as well, what about some of like, 10 kilowatt hour or 20 kilowatt hour batteries, accessory use batteries, like do they have to be included in this process? And I'm not sure that it's clearly written out that they're clearly written out as exempt from the site suitability, but not from the other requirements. So uh, maybe that's somewhere to be looking into.
Absolutely. Thank you. Yeah, we recognize that there is definitely a gap with the residential battery systems, and we, in the next iteration of the guidelines and the regulations, we want to ensure that those get exempted from the process as well. Because you're absolutely right; those are not currently exempt, but we should be exempting those.
Let's see. Can you repeat what you said about groundwater protection district? Yes. Under the guidelines that are established by DOER, I think I have this, if I have this right, all clean energy infrastructure facilities are prohibited in zone one areas, and specifically uh, battery storage projects can be prohibited by the municipality in zone two areas, all subject to requirements under 310 CMR 22. Let's see, I think we just talked about small scale batteries. See, if all municipalities need to update their bylaws, the proposed timeline is too short. Lincoln's town meeting is in March, so this timeline where there's still so many answer questions. Yeah, I think that's definitely something that we have been thinking about, that like not everybody holds a fall town meeting, and if that's the case, March 1 is usually too late for municipalities to add something new to spring town meeting. So it's definitely going to be one of the comments that we're going to be submitting. Any other questions or comments? Yeah, that's definitely the schedule that we had in mind, Talia, for why just a lot of communities aren't going to have fall town meetings, and um yeah, there's needs maybe something more like, I think that I recognize why December 1st is the date, just because I know it's in part tied to trying to help folks with getting access to federal incentives before they run out. But also I'm concerned that it's just not. I'm not concerned about being realistic. Yes, these are draft regs and guidelines. And again, here's the info on public comment. Highly encouraged to submit them. I think, I've uh, met and spoken with the DOER folks and the EA and the EFSB folks many times. I think they're all very responsive to feedback. I think, by their own admission, that, the pace at which these had to be built out, which has been very challenging and very, very accelerated, may have led to things that they may have overlooked, and they have been, they are very receptive to clarifying questions, which you should direct to your regional coordinator, and to comments on the overall regulations and guidelines. And yeah, I think that's one of the challenges, Alicia, is that, there's a little one size fits all here, and whatever things has to be um, set up for both, Boston and Cambridge and Somerville, and, the smallest towns out in Western and Central Mass. So I think there may be opportunity to create some more nuance within the regulations. How best to define that is, I think, definitely something worth discussing further. And uh and Paula, yeah, I mean, I have a lot of sympathy for DOER because uh they, of all state agencies, are required to submit their regulations to the legislature, and that adds 60 days to any regulatory process that they undertake. So I also see that's why so much of what their regs are is built out in guidelines, which have a different pathway for public input and review, and will enable them to make changes differently in the future. Uh, with that, thanks everyone so much for your time and for joining us. If you have any questions, feel free to reach out to us. Going to pivot from this to developing our own comments to submit to the process. So if there's things you'd like us to really highlight, please don't hesitate to reach out. Always happy to talk more about sort of our understanding um, of the draft regulations so far. Thanks so much, and thanks so much for joining us, Connor.
Thank you, Jeremy. Really appreciate it, and look forward to any additional comments from people.